Namaste, good morning. Welcome to episode number 102 of AAA weekly webinar series. We first of all, greetings on Holy Festival to all our audience, to all our viewers. My dress also little bit signifies the colorful festival, and wishing all a very, very happy Holi on this event. Friends, in the last episode 101, we discussed about various provisions where the insolvency professionals can be reprimanded, penalties can be imposed on them for any contravention of IBC or regulations made thereunder. We discussed about Section 217, 218, 219, and 220. Section 220 deals with the Disciplinary Committee of the IBC, or Disciplinary Committee of the IBBI. Today, we will also highlight, first of all, we will go through the provisions where the Insolvency Professional Agency can also initiate disciplinary proceedings against their members, insolvency professionals, and also their powers to levy penalties. The penalties which actually we saw that can be levied under Section 220 on insolvency professionals or on IUs or on IPAs, that was 3 times the gain or 3 times the loss caused to others. And in case this is not quantifiable, then the maximal penalty can be only 1 crore. However, today we will see that for various non-compliances, what are the provisions of penalties that can be imposed by IPA, Insolvency Professional Agency. So looking into the past, we actually can see when we saw this Section 220, and let us now try to understand what exactly the provisions says. So the first of all, we actually would like to say that the penalties and all these provisions are basically only since the insolvency professionals are entrusted with a lot of powers and also with the responsibilities. So in fact, the power comes with responsibilities. The matter of resolving distressed companies is very important. And this is the first time in the history of independent India that a private person has been given such powers that he can immediately start operating the bank accounts of a company, even if that company has a turnover of 10,000 crores a year. The insolvency professional, when appointed as IRP, can take control on the bank accounts of the company and can take control on all the operations of the company. He is responsible for making sale and purchase. When it comes to the liquidator is also given substantial powers. Of course, gradually the liquidator is now supposed to consult stakeholders consultation committee, but in case you see initially how this liquidation law was formed, it was basically a very, very independent power given to the liquidator, and because of those powers, the liquidators can have access, control, custody, and powers to sell assets worth crores of rupees. And at that time, when there was no provision for stakeholders consultation committee, it was very, very important to make all these provisions. Even now, these are very, very important. Even after we do the consultation with the stakeholders consultation committee, but still the powers of the liquidator are substantial. Therefore, with the great powers comes the responsibility. So therefore, the regulations are made by IBBI and by for IPA to issue SCN, show cause notice, to investigate, to inspect their affairs, and also to find out whether there is any contravention of law or not. And if the contravention is found, then the various kind of recommendations like suspension of the registration for some time or cancellation of the registration forever. Second, imposition of penalties. Third, issue of warning. Issue of warning is the least possible reprimandation, least possible action against the insolvency professionals. When we come to see this enforcement mechanism, the section 220 that we have already discussed in episode 101, and that was the powers of IBBI under the IBC to monitor and to impose penalties and to reprimand the insolvency professionals. When we see when we try to see the what are the actual provisions where the insolvency professionals are supposed to have some obligations under the law. Now, the obligations under the law is found in section 208 of IBC. Now, it says that every insolvency professional shall abide by the following code of conduct. Shall abide by the following code of conduct. This is something which section 208 says. It says to take reasonable care and diligence while performing his duties. Reasonable care and diligence while performing his duties. To comply with all requirements and terms and conditions specified in the bylaws of the Insolvency Professional Agency of which he is a member. Then there is a code of conduct which is the model bylaws given by the IBBI as per the regulations. In the model bylaws, the code of conduct is also mentioned. And in that code of conduct, there are various clauses, and the insolvency professionals are comply with all the clauses of that model bylaws given by IBBI by way of a regulation. To allow the insolvency professional agency to inspect his records, because the insolvency professional agency is inspecting our records, they can start inspections, and then to submit a copy of the records of every proceeding before the adjudicating authority to the board, as well as to the insolvency professional agency of which he is a member. That's another obligation on the insolvency professional to perform his duties in such manner, subject to such conditions as may be specified. So whatever may come from the IBBI, whatever may come from the IPA, we have to comply with, and we have to conduct the assignment according to that. So this section 208, even this section 208 is mentioned in section 93, that is the standard of conduct. No, section 93 says the resolution professional shall perform his functions and duties in compliance with the code of conduct provided under section 208. Then similar provisions are found in section 120, and similar provisions are found in section 143. Why? In three different sections of the code, the similar provisions are found. As we all understand that the IBC is divided into parts, and each part is divided into chapters. So this particular section, like section 93, is referring to part 1, section 120 is referring to part 2, and section 143 is referring to part 3 of the code. So therefore, in all the part 1, part 2, part 3, the standard of conduct is defined, and finally referring to section 208 of the IBC. Finally referring to section 208 of the IBC. So that's very important that we are under obligation to comply with section 208. So when it comes to 208, it first of all, it comes as the reasonable care and diligence. Second, it comes with the IPA, the bylaws of the IPA, the terms and conditions of your appointment as terms and conditions of becoming member, that is the bylaws. And the third is to allow the inspections. And the fourth is that to submit all the records and any other regulations. So what is most important is the clause B of section 208, which refers to the code of conduct. And then the code of conduct can be found in bylaws of IPA, and there are different clauses. So when it comes to the contravention of duties, so then the action actually starts, and enforcement has to be done by the IBBI. So these are various enforcements and various kind of actions that can be taken against the insolvency professionals. So when we see IBBI, model, bylaws, and governing board of IPS, this regulation to 2016 regulation, and when we see regulation 23 of this model bylaws, it allows the IPA to initiate disciplinary proceedings by issuing a show cause notice against a professional member. And that can be issued by way of based on a reference made by the grievance redressal committee, and SCN can be issued based on the monitoring of the professional members. SCN can be issued following the directions given by the board or any court of law. Then suo motu, based on any information received by it. So IPA can receive information, IPA can receive grievance, IPA can actually monitor on itself, and IPA can receive directions from the board or from any court of law, maybe NCLT, NCLAT, or any other. Now, coming to section 23A, which was inserted later, it says that the authorization for assignment shall stand suspended upon initiation of disciplinary proceeding by the IPA or by IBBI, as the case may be. This is part of regulations made by IBBI as model bylaws for IPS and governing board for IPS. Now, the explanation says that any disciplinary proceeding shall be considered as pending against the professional member from the date he has been issued a show cause notice by the IPA or by IBBI. So the disciplinary proceedings would be considered as commenced when the SCN is issued. Because before the SCN is issued, there is a prima facie case against the insolvency professionals. That is what has already been established either by the IPA or by IBBI. Therefore, the disciplinary proceedings means issue of SCN, because there is a lot of work which has already been done by IPA or by IBBI before SCN is issued, and there is a prima facie case. So that is what is called disciplinary proceedings. So till the disposal of the disciplinary proceedings, the AFA would remain suspended. Now, the Regulation 24 of Model Bylaws for IPS says the manner in which the disciplinary committee may ascertain the facts, because this actually it provides a Regulation 24, and also the issue of show cause notice based on the facts. Then how to dispose of the show cause notice by a reasoned order following principles of natural justice. Timelines for different stages of disposal of the show cause notice, and rights and obligations of the parties to the proceedings. Disciplinary committee, whenever there is an order which actually is issued, that shall include like what are the kind of reprimandations that can be given to insolvency professionals. That can be expulsion of the member from the membership, suspension of the professional member for a certain period of time, cancellation of authorization for assignment, AFA, admonishing of the professional member, imposition of monitoring penalty as per the table mentioned below. So the table mentioned below is very, very important, because the non-compliances are something that we can even forget, we can even forget, we can even skip. But in case you see the kind of penalties, after this learning, I would believe that it will be very difficult to skip a timeline. It will be very difficult to skip a kind of a non-compliance, which is a technical non-compliance. Now, in case we see the penalties table shows very clearly, and the penalties are basically referring to, one is the maximum amount, and the second is the some percentage of the fee that the insolvency professional has earned from this case, whichever is higher. And then there is a minimum penalty on this kind of non-compliances. So the minimum penalty is 50,000 and the maximum is 2 lakhs of rupees. However, whichever is higher, and that means that there is a amount, maximum amount, then there is a relation to the fee, then whichever is higher. So the higher can it be some percentage of the fee. If the fee is very high, then the penalty can be very high. And if the fee is lower, then it can be maximum or the minimum. There are two ranges. One is maximum, one is the minimum, and the third is some percentage of the fee. And if the some percentage of the fee is very high, so then there is no upper limit. Then there is no upper limit. In case I'm earning about 1 crore of rupees from a particular assignment, and it says that the 25% of the fee, then it becomes 25 lakhs. So that 25 lakhs will be the penalty in this case. Now this fails to submit disclosures, returns, etc. to IPA, or submit inadequate or incorrect disclosures, returns relating to any assignment as required under the code and regulations made thereunder or bylaws of the agency or called upon by the board or the agency. So like basically non-submission of disclosure or non-filing of return, or incorrect submission of disclosures or incorrect particulars in the return, up to 1 lakh of rupees or 25% of the fee, whichever is higher, or minimum 50,000 rupees. Second, accept an assignment having conflict of interest with the stakeholders. Like if I'm accepting an assignment where I have the conflict of interest with the stakeholders, then I cannot accept that. Stakeholders will include like all, including the management of the company to the committee of creditors. If I'm not independent, if I have a conflict of interest, then I cannot accept that assignment. Penalty, 2 lakhs rupees or 25% of the fee, whichever is higher, minimum 1 lakh. Fails to maintain records properly relating to any of his assignments. So I'm obliged, I'm under obligation to maintain proper records. If I fail, 1 lakh or 25% of the fee or 50,000 rupees is the minimum. Now, this is important. Reject a claim without giving any proper reason while undertaking an assignment, or fails to exercise due diligence in claim verification. So for claim verification, greater responsibility lies with the IRP, RP, or the liquidator. So therefore, the penalty is 2 lakhs rupees or 25% of the fee, whichever is higher, or minimum 1 lakh. Fails to comply with the directions issued by the adjudicating authority or the appellate authority. Of course, like any directions given by NCLT or NCLAT, the penalty is 2 lakhs, 25% of the fee, or whichever is higher, or minimum 1 lakh. Outsource his duties and obligation. Now, when we are saying outsourcing his duty and obligation, I'm also referring to some of the orders of IBBI, which says that as far as this auditing is concerned, valuation is concerned, these can be outsourced. Like other actions, other tasks of the IRP, RP, or the liquidator are not supposed to be outsourced. And in case it is outsourced, then a penalty of 2 lakhs or 25% of the fee, but minimum is 1 lakh. Fails to appoint registered valuers whenever required under the code or regulations, or conducting evaluation, penalty 2 lakhs or 25% of the fee, minimum is 1 lakh. Fails to supply the information called for or to comply with the requirements of IPA, IBBI, NCLT, NCLAT, or any other authority, the penalty is 1 lakh or 25% of the fee, whichever is higher. Fails to make public announcement in the manner provided in the relevant regulations, 2 lakhs, 25% of the fee, or 1 lakh is the minimum. Fails to provide notice regarding meeting of the creditors, like the notice must go to all. So in case notice is not going to all, so the penalty is 1 lakh, 25% of the fee, or 50,000 rupees. Then very important is that the responsibility of accepting a resolution plan for ineligible resolution applicants lies with the insolvency professional, lies with the RP. Now, fails to reject resolution plans from ineligible resolution applicants, that is also penalized to the extent of 2 lakhs, 25% of the fee, or minimum 1 lakh. Fails to take action in respect of avoidance transactions. Fails to take action in respect of avoidance transaction is also, again, similar kind of penalties are levied. Enters into contract or agreement with professionals in an incomplete or improper manner. If I'm appointing a valuer and I'm not giving an engagement letter, in the engagement letter, I'm not mentioning the scope of work, mode of payment, and the kind of payment. So these are improper or incomplete appointment. My scope of work must be very clear, and I should also have the quotations, and the similar scope of work is communicated to all people who are giving communications. That is what is a proper process which is conducted for appointing a professional and preparing a scope of work, preparing an engagement letter. In the engagement letter, the scope of work must be mentioned and it should be accepted by the professional. The mode of payment and the time of payment also must be accepted there. So that is what, in case it is not, then it is a penalty of 1 lakh, 25% of the fee, or 50,000, which is the minimum. Contravenes any provision of the bylaws or regulations for which no specific penalties have been imposed. Therefore, a last residual section, that is again minimum penalty 50, 25% of the fee. So the 25% is common in all penalties. 25% of the fee is common in all penalties. However, the maximum penalty, which is without comparing to the fee. So then that is the maximum, and minimum is also mentioned. Maximum is 2 lakhs, minimum is 50,000. However, the maximum would not be applicable if 25% of the fee is higher than the maximum. Then the 25% of the fee would be applicable. So this is very clear that we actually have various penalties, and it is important that we should go through and go to all these penalties, and we should guide our team. As a learning from this is that we should try to guide our team. So Ankit, this is what is the penalty provisions, and I think when we try to see the penalties, and I think this is actually makes us to again look back into the timelines that we all are trying to teach our team. We should actually have a kind of a table. I believe a software will actually help, because doing multiple cases and in case of missing any kind of regulation timeline would be very, very fatal, and it also impacts the kind of credibility of the insolvency professional.
So there are a few questions that I think we can take up at this stage. Mr. Hari Prasad is asking that if SCN is issued during the term of the IP being an IRP, can the IRP continue to be the RP of the same assignment?
Sorry, I couldn't hear, Ankit. I was just referring to. What is that?
So I'm saying that if SCN is issued during the term of an IP working as an IRP, can the IRP continue to be the RP of the same assignment?
Yes, the show cause notice is only suspending your authorization for assignment, AFA. It is not suspending your, it is not cancelling your membership. It is not cancelling your registration with IBBI. So for continuing an assignment, you need you need the membership of an insolvency professional agency, and also you need the registration with IBBI. So these two conditions are continuing. So therefore, you can continue with your existing assignments. However,
but there is an NCLT application or NCLT intimation that goes even when the IRP is being confirmed as the RP, right? So does that not require a valid AFA?
No, see, the IRP to RP is a continuation of the assignment if it is not changed. If it is not changed.
So there is no fresh AFA required.
So there is no
if you had
fresh,
an AFA at the time of your appointment as IRP and you are
yes,
continuing as the RP, there is no change there.
There is like, see, in case we see the NCLT in CDV code at the time of appointment of IRP, they are required to see the board and they are required to see the disciplinary proceedings. But like when the same IRP is appointed as RP, then it is not required.
Then Mr. Hari Prasad is also asking, then can appointment of manager to manage the day-to-day affairs of the CD be considered as outsourcing? I think manager employees can always assist an RP in doing the work. I don't think
that is
that's a
all
problem.
with the approval of CD. Not
then
with
of course,
not with the approval of COC.
Then there is a question that please highlight penalty relating to individual insolvency. And then there is also a question that what are the compliances for PG cases and also what are the compliances for IPE with respect to, of course, the requirement that you suggested for the RP, for the IPs.
So when I started with section 217, in fact, started with 208, that is applicable to insolvency professionals. 217, 218, 219, 220 is all applicable to insolvency professionals. When I see the penalties to be imposed by the IPA, it is to the insolvency professionals. It is not at all referring to, it is not at all referring to anything which is like the personal insolvency, or in fact, I would like to highlight, Ankit, it is a very, very important question. So I would like to highlight one important part, which is the section 208. Now, section 208 says that in the following matters, I'm saying that where any insolvency resolution, fresh start, liquidation, or bankruptcy process has been initiated, it shall be the function of an insolvency professional to take such action as may be necessary in the following matters, namely a fresh start, insolvency, individual insolvency resolution process, corporate insolvency resolution process, pre-packaged insolvency resolution process, individual bankruptcy process, liquidation of the corporate debtor. So everything is covered very, very clearly in section 208. So therefore, all these sections, 208, 217 to 220, model bylaws for IPA, everything is applicable to all the assignments.
So then we have so question from Balakrishnan ji. He says that are the penalties practically imposed by IPA or IBBI for each and every default? Are there not any cases where the misses in the clauses are not pursued by IPA, IBBI and penalty imposed? There are cases where the IBBI has left and said, passed a DC order and said that, okay, the RP apologized and the RP said he will be conscious in the future, and they have not levied any penalty. They have passed several orders like that.
But there are orders where the penalties have been imposed by IPA also.
And
So
there are
like
also,
everyone has seen the IBBI orders, but probably we are not very regularly visiting IPA websites. In case you go to IPA website, you will also find various orders issued by IPAs where the penalties have been imposed.
IBBI website has a part where you can dig out the disciplinary orders passed by IPAs.
So IBBI website also has that part. So it is our learning is that we must see these orders. After this discussion of question answers, then I will go to analyzing about 10 recent orders of IBBI, and we will not highlight the name of the RP. We will not highlight the name of the corporate debtor for hiding the names of the. We are only trying to understand the subject and the kind of reprimandation by the IBBI, because everyone is our professional colleague, so we will not highlight their names in our discussion on IBBI orders.
Then we are looking at a question from question that is that if a professional CEO is appointed during CRP, will the RP be responsible for his actions? The overall
Yes.
responsibility of the company remains with the RP, and it
Yes.
is under his guidance or his management that the CEO is working. The way directors are responsible for the work of a CEO, I think similar thing will remain here.
Right.
Then Sandeep Goel is asking, can IPE give interim finance to assignment handled by partner of IPE while interim finance is approved by COC and no fund is available at competitive rate?
Yes, the IPE can give finance with the
Yes.
approval of the committee of creditors. In fact, I have sent this query to IBBI before. In fact, I funded in one case because of the urgent need of the funds. I funded interest bearing to the CIRP cost urgent expenses. I sent a query to IBBI. So IBBI said this is the matter between the COC and the RP. If the COC approves, then it is okay.
Then are all penalties essentially imposed with a DC order?
Yes, all the penalties are supposed to be imposed with a DC order. There is no direct levy of penalty, only on account of finding of something. I think the penalties can be imposed by the DC orders.
Right.
I can actually see again this part. This is a very, very important question. because I can see this, the orders, yes. Because see, when we see this regulation 24 of model bylaws, orders that may be passed by the disciplinary committee shall include. And when we see A, B, B, A, C, D clauses, it is the imposition of penalty as per the table below. So the table below is basically not automatic penalties. It has to be backed by a disciplinary action and SCN and then an order of TC. Yes, Ankit, it was a good question. Thank you.
Then we are saying that in voluntary liquidation, after submission of preliminary report to CD, liquidator received email ROC registered from the company informing that they have changed the liquidator and instructed not to communicate with any stakeholder, but name of the new liquidator not given and no liquidator called to take charge. What is the obligation of the outgoing liquidator?
Now, see, I think the question is that the outgoing liquidator is removed.
After submitting the preliminary report, the liquidator who was appointed for voluntary liquidation of the company has been told that now your services are no longer required. So this is the status. This is what Rajesh
So
Goel is asking.
you see, in the voluntary liquidation, the board of directors are still active. Okay, so in case they are saying that your services are not required, that means that they would appoint a new voluntary liquidator, and it is not really possible that the voluntary liquidation is closed. Either they will appoint a new liquidator, and so in between, the old liquidator cannot take any action and cannot take the process forward, and the new liquidator would be appointed. So in between,
So
I
the
think the board of
liquidator will
directors,
simply hand over all the documents to the company in
yes,
case that
yes,
is what is the question, that handover, who to give the handover. So you can give the handover to the company.
yes, company, because the directors are active in voluntary liquidation cases.
Then we have a question that as per new regulations of IBC to hold COC meetings quarterly or monthly, it is applicable to those CDs whose resolution plan has already been approved by the COC and pending approval. Yes, it is applicable. There is no exemption there in that section. But what you can do is you can call a COC meeting and seek COC's consent in case they would want to extend that to a quarterly meeting. In several cases, however, COC members are saying that we would want a monthly update from you on what is the status of the resolution plan and other matters, and they are like open to the idea of having a monthly meeting as well. Then we have a question from Sandeep Goelji that as per the insolvency resolution regulations, IPE can provide all kinds of services except valuation and audit. Then the question is, if IPE is providing legal support services and filing the disclosure of appointment of IPE and not of the advocate through which IPE is providing the services, is it a default? IPE will never be the IPE can always say that yes, it is taking care of the litigation matters, but then the wakalatnama will always be in the name of a lawyer, right? The
Yes.
people who will be working there will always be lawyers. So they lawyers or chartered accountants, as the case may be, who can represent an NCLT. So there again, I think the relevant professional disclosures have to come forward.
No, the first is that this provision is
Hmm.
applicable only in those cases where IPE is appointed as IP. It is not applicable in other cases.
So
In
IPE
case,
will not disclose anything because IPE is itself the IP here, right?
no, IPE it itself is IPE. So in case the IPE is also kind of
Taking care of
uh,
the legal support
doing the
services.
legal support, then the IPE can go to COC for a separate fee approval. And whatever that fee approval would be, that has to be disclosed to IBBI and nothing else. Because see, in case the legal services are also being handled by the IPE, but then in that case, IP must have a partner who actually is a lawyer. And that can be done only in those cases where IPE is the IRP, RP, or the liquidator, and not in other cases for the time being. In other cases, appointing a related party as a professional, that actually would be kind of a code of conduct issue.
So Balakrishnan ji is saying that in case, let's say that there is a high court, any other forum gives an order which also restricts the IRP or the RP in doing certain things, then is there any non-compliance and penalties, assuming that the restriction order in this case is not a clear? So basically the restriction order, he says, is not clear. It is not staying the process. and it is not even letting the RP do his work. So there is ambiguity in the order. So what should be the RP's stand be? So there are certain judgments which talk about what a stay would mean, what the NCLT orders can be read as whenever, or other orders with respect to, barring the RP to do certain things. So barring that, everything else should be done. So like in for example, in case, let's say the High Court says you should not consider resolution plans, the COC should not consider resolution plans. So you can do everything else. So this is what I
Yes,
think
I
that can be
believe
done.
like the CIRP forms 1 to 8, in case of any state, IBBI say that you continue filing the form every month till the period the stay is continuing. That is the one obligation on the insolvency professional. And the other obligation is like in case there is any uh, ambiguousness in the order of any court, then we need to file an application for clarification. And if that application for clarification is filed, that will show the due care has been taken by the insolvency professional. But in case the application for clarification is also not filed, and something which is being done which is not the obvious meaning of that order, then of course it can be difficult to prove that the intent was correct.
So I think we're done with the important questions.
So going forward, going forward now, we are saying one, it is very important that we have already seen that for all these penalties, the reference has to be like there has to be a disciplinary committee that passes the order, and also why we are saying that we actually now try to find out the various orders which has been passed recently by IBPI. So one, I would actually say one order which is passed in the month of March, and there are various contraventions, and I will first see the contraventions and then the observations of the disciplinary committee. Now, the uh, first kind of objection raised by the IP against the issuance of SCN, that was the inspection was initiated by an officer lacking the requisite authority, and it was stated that the inspection can be exercised only by the designated executive director. However, in the present case, the directions were passed by the assistant director or the assistant general manager. Now, in this case, the disciplinary committee, the DC says that the inspection has been approved by an officer having the designation of executive director, while the communication was made by the assistant general manager or the assistant director. Therefore, there is no such infirmity with the code. Then the IP again argued that the SCN was issued without necessary jurisdiction as it was issued without completing an inspection or investigation as required by section 219 that we discussed in episode 101 of the code and regulation 12 of the inspection regulations. Now, in this case, the DC says that the inspection was conducted in accordance with the functions of the board provided under section 196. So the DC says that no, the inspection was conducted. So therefore, what actually DC wanted to say that the inspection was conducted based on the documents submitted by you. So the inspection of the documents can also be considered as inspection. This is what I understand. No, addendum to the DIR, despite being a material document, was not provided to the IP. So it is said by the DC, since the no charges were made in the addendum, so no prejudice can be said to have been caused by not sharing this. Now the language of the, now further the IP says that the language of the show cause notice is as if the board has prejudged issues against the insolvency professional. Now it is the DC says that the SCN says that the contraventions, if established is important, will make an IP not a fit and proper person to act as an IP. So these were the various replies given by the DC, because see, this, I just wanted to highlight because the various insolvency professionals have started taking those arguments which actually have been taken as giving some stays to the insolvency professionals. Like there is a judgment of Bombay High Court where the stay was given to the insolvency professional against the order of IBBI. There is another judgment from Ahmedabad where the stay was given based on one argument that the DC was only having one member. So there was another person like so these are the arguments which are basically pending before the high courts, and the stay is temporary. However, we are only trying to say that what DC replied on these, again, observations of the insolvency professionals. Now, in this case, the basic contravention which was found by DC was that the liquidator's fee, in fact, the insolvency professional received an excess liquidator's fee amounting to about 83 lakhs due to incorrect categorization of realizations during the specified period, resulting in a miscalculation of the fee. Now, in this case, the insolvency professional, the IP, said in its reply that this excess amount was given back, it was refunded, and then it was the DC says that it's important that to be vigilant, and in case of such refund, it also shows that it was earlier taken, and it actually is not showing the good intent. It contradicts the intent. Then returning the fee also kind of, it doesn't mitigate the original contravention. So then also in this particular case, the IP also has another LLP, not an IPE, but the IP has another LLP, basically for providing some support services or for some consultation services. So in this case, the IP has actually engaged that related party entity, which is not an IPE, but a separate LLP, for providing liquidation assistance. The liquidation assistance is in fact approved by the Committee of Creditors. Like that is something which is continuing from the CIRP period, because earlier the same IP was the RP and the same LLP was providing assistance to the RP. So that the liquidator also continued with the same kind of assistance from the LLP. So engaging the entity significantly higher fee than the liquidator without a change in the scope violates the purpose of the appointing professionals and raises concern about the fairness and potential malfeasance. These are the contraventions which is highlighted. Now the IP in fact states that the creditors meeting with the entity continuing to assist him, leading to filling of the liquidation application. Because see, the IP says that when the liquidation application was submitted, before that there was a committee of creditors meeting, and this particular LLP's assistance as would be provided to the liquidator was approved. And then the IP says that the reasonableness of the fee that should be evaluated based on the specific circumstances of a case, size, complexity, highlighting his efforts. So various efforts were made, various e-auctions were conducted. That's what he highlighted. So at the time of COC decision, he further says that at the time of COC decisions to initiate liquidation, there was no legal obligation for the COC to approve the fee of the professional advisory firm. Despite this, the IP transparently informed the COC of his intention to appoint his LLP, demonstrating his commitment to openness and honesty. Further, RP argues that his LLP's higher initial fee was justified by the greater workload during the liquidations in initial phases, like the front loading, like the kind of claim verification, and understanding the assets. So therefore, all these arguments finally, when it came to the DC, the DC finally said the liquidator's fee structure along with the LLP's assistance mirrors the previous arrangement during RP's tenure, implying a continuation of the fee structure under which the RP was supported by the LLP, that is not supported by the DC. Liquidation regulations stipulate that the liquidator should engage professionals only for tasks falling within the expertise of another professional, such as legal, accounting, valuation services. Tasks exclusive to the liquidator's domain, like claim verification, asset custody, creditors' claim settlement, would not typically require external professional assistance. Liquidator's fee structure under Regulation 4 actually has been structured in such a manner that it compensates all the duties to be performed by the liquidator, and it is not supposed to have separate fee for every different task. So the DC finally say that the whatever charge was there in the show cause notice is all upheld, and therefore the DC is not saying that anything. The DC has not accepted any of the submissions of the RP. For the same RP in another CD where he was the RP, and it was also saying that the in this particular case the IP was not able to take the necessary transaction review audit as mandated, and it was the IP said that the transaction review audit auditor was appointed. Appointment was essentially for reviewing suspect transactions, avoidance transactions, and therefore the IP faced delay because of the management's slow information provision, and there was a delay. So there was a delay in transaction review audit. So then he said that the COC was also informed. So, but then DC was very clear. One, the DC failed the final obligation, the final allegations by the DC that the IP fails to inform the COC about non-furnishing of the information by the CD. Discontinuation of the follow-up after a particular date by the RP. Failure to take definitive action such as filing of an application under Section 19(2), that was also not seen. So the application under Section 19 subsection 2 was not filed. The information follow-up was slow. The information was not given by the management. The transaction review auditor was not appointed, or it was not concluded. So all this taken together, the DC was of the opinion that the RP has contravened the provisions. So the registration of the RP was suspended for 2 years, and also the IP was directed to deposit half of the fee paid to LLP as penalty within 45 days. And this penalty doesn't go to IBBI's own account. This penalty goes to Consolidated Fund of India. So the penalty goes to Consolidated Fund of India. But surprisingly, when the IPA levies the penalty, it goes to IBBI fund. And IBBI can use that fund for their own regular expenses. However, when the IBBI levies the penalty, it goes to Consolidated Fund of India. There is a difference. So when the IPA levies the penalty, it goes to IBBI. So Ankit, we can continue with the orders reading. Yes, Ankit. Should we continue orders reading?
I'm saying yes, we should continue. We have 10 more minutes, so we can see if that I think would be the next. Yeah.
So the next is a very simple, that the valuers were not appointed by the IRP, RP, and then also some discrepancy in the assets to be valued, that was also found by the DC. Even if the RP says in this case that the CD was struck off and it was dissolved under Section 248 of the Companies Act before the initiation of CIRP. And the financial creditor, in fact, failed to disclose this to the adjudicating authority while getting the order for initiation of CIRP. The IP say that he appointed 2 valuers, but their fee was not approved by the SEOC, and thus were not included in the CIRP cost disclosures, because the fee was not approved, so it was not disclosed in the CIRP cost disclosures, despite their bills were submitted. And he further clarified that the valuers independently conducted the valuation process, sourcing information from the local records and personals. And also the IP submitted that at the time of valuation, there were no specific regulations governing registered valuers, having no fixed standards. So finding the DC concludes that the IP's failure to review the valuation report, which clearly states it was commissioned by someone else and the property did not belong to the CD, demonstrates negligence. Hence, the charges in the SCN are upheld. Now, in another case of the same IP, non-appointment of valuer is again a question. Non-appointment of a valuer is again a question. And in this case, also the IP says that since someone else was appointed as RP by the COC during his tenure as the IRP, his responsibility of appointment of valuer fell on the RP and not on him. But in this case, the finding says that even if the IP is replaced by the COC, till the time the new person is appointed as RP, it is the duty of the IRP to continue and work as deemed RP. So he is under obligation to appoint valuers within 40 days. So therefore, in case the valuers are not appointed within that particular period, so therefore it is a violation. And in this case, even there is a third case of that particular insolvency IP, where the non-cooperation by the IP in the conduct of inspection. And the third allegation against this IP was that in he was not providing minutes of 1 or 2 meetings. The finding was that the minutes were not providing. There was a delay in relationship disclosure, and there was also delay in relationship disclosure of another CD. So all this taken together, the DC finds that this is all these taken together are non-compliances, non-appointment of valuer, even if the fee is not approved, non-appointment of valuer, even if you are removed by the COC and your adjudicating authority has not yet appointed the RP, delay in providing the inspection documents, and also kind of this is finally the DC imposed a penalty of ₹2 lakhs on the insolvency professional, and this money will go to Consolidated Fund of India. Another order in February 24. So we are trying to learn, like in this particular case, it is a case of liquidation. The anomalous and non-transparent sale of assets of the CD by the liquidator. So in this case, the liquidation process was delayed because of in the e-auction, due to disqualification of several bidders and resulting into prolonged process, the liquidator's failure to communicate the ineligibility. So basically what happened, because there were many bidders and some of the bidders, they actually were conniving with each other. They were cartelizing with each other. And in fact, their documents were also seen as if submitted by one person. Their handwritings were common. Their all other details, all other particulars were as if mentioned and written by a same person. So that was the finding of the liquidator, genuine finding of the liquidator, that there is a group of 4 people. They are in fact cartelizing and they are submitting papers, and this is nothing but one person. So that is the genuine thing. The only thing which is the mistake, that the auction was conducted, and in the auction everyone participated, even those who are actually cartelizing. And this particular the information about this cartelization, the disqualification of the bidders, actually that came after the e-auction. Like finding the cartelization was not bad, finding the disqualification was not bad, but announcing all this after the e-auction is completed, that is a bigger difficulty, where this insolvency professional failed. And the DC finding was as under. The IP admitted that 4 applicants were part of a cartel, leading to their disqualification, while 2 applicants were defective. However, communication regarding the ineligibility was delayed, reaching the concerned applicant in the day after the bidding process concluded. The DC clarified that the IP's attempt to equate the processes of submitting resolution plans in insolvency resolution with e-auction in liquidation was flawed. And the DC emphasizes that the transparency and fair participation in auction processes are crucial for maximizing the value of the asset under the code, urging the liquidator to inform prospective bidders adequately in advance to enable them to cure defects. And finally, the order of the disciplinary committee was that this insolvency professional registration was suspended for 2 years. Registration was suspended for 2 years. Now, other order, which is in the month of February 24, and this was regarding constitution of the COC with the related parties. So, in fact, the IP, in fact, something which is also, I feel it is bad, that the IP was appointed as director of 2 companies during the CIRP of a 3rd company. And when it was found that where the RP was appointed as director, these 2 companies were the related companies to the CD, because one of the shareholder was having interest in these companies. So this was also, according to my understanding, it sees like there is a kind of connivance. So this is a case where the insolvency professional was appointed director in 2 companies, and these 2 companies were related to CD, and this was all done during CIRP. This was all done during CIRP. So therefore, in this case, the finding of the DC, it highlights that it was highlighted by NCLAT, and it was distinct from focusing on the appellant's plea for consideration of its compromise scheme and stay on auction proceedings due to alleged unreasonable auction by liquidator. It is alleged that the IP's appointment as a director in the company during CIRP violates Regulation 3(1), which prohibits an insolvency professional from being appointed as the resolution professional, and the acceptance of directorship during CD, where interrelationship exists with the CD stakeholder, compromises the RP's independence and impartiality. And in this, the order, the registration of the insolvency professional was suspended for 3 months. The registration of the insolvency professional was suspended for 3 months. So in another order, in February 24, the COC meeting was not conducted, and it was in the very first meeting. The COC rejected his appointment by 59%. So it was rejected, and then the COC was requesting the RP to conduct another meeting, because in the other meeting they wanted to select another person, but the second meeting was delayed. The second meeting was delayed beyond reasons, and the complaint was also filed by the creditors. Now, the insolvency professionals submitted that the second meeting, in fact, was conducted, but it faced some technical difficulty. So therefore, the creditors decided, and they unanimously agreed to adjourn that meeting. And in the meantime, some complaint was also submitted. Finally, the findings was that the DC observed that there is a series of the events surrounding the replacement of the IRP with IP as the RP, highlighting procedural irregularities and subsequent approval of the resolution plan by the COC and the adjudicating authority, adding complexity to the complaint. DC accepts the submission of the IP. However, the fact that the IP did not call the COC meeting as requested by the financial creditors holding 59.11%, and that cannot be ignored. So it actually would be found as violative. However, the lenient view would be taken because subsequently the same IP was appointed as RP, and then the resolution plan was also approved. The company was also resolved. Therefore, the case was closed with warning to be careful in future. In another case, in January 24, the sale of the process of the assets were in fact challenged. The sale process was challenged because there was a typographical error in the auction notice, and then the typographical errors in the expression of interest, EMD, and it was only the State Bank of India, in fact, that was the only creditor, and in fact, the SBI objected to all this, but finally, the liquidator conducted the process of liquidation and the process of auction hurriedly, and everything was done within 7 days. Somehow like the insolvency professionals said that there was a delay in taking the possession of the assets of the CD. There was an issue regarding the leave and license agreement, and in necessity, the intervention of adjudicating authority was also required, and it was done. And then there was a difficulty in getting the eviction from the existing occupier. Then the also insolvency professional highlighted, the liquidator highlighted that the earlier 2 auctions failed, and we never wanted that the third also should fail. And in it was also like kind of rumors. There were rumors in the market that the property value may decrease. So therefore, the process was hurriedly conducted in 7 days. The DC finally found that it was lacking transparency, and the SBI also issued a warning. This process was lacking transparency. And then for the same IP, there was another case where the public announcement was delayed by, in fact, it was a case of public announcement it was supposed to be on 5th of October, on 29th of September. It was delayed by 3 days because of the weekends or because of the holidays. But somehow, in the meantime, it was withdrawn also. The Form FA was also filed. But this was also considered that the public announcement cannot be delayed, even if there is a settlement talks going on, and even if finally it was found that it was also a contravention. So in this case, the order was that the insolvency professionals registration was suspended for 2 years. So this is, Ankit, otherwise there are many judgments that there are many orders that we can discuss. In case we can take some of the questions and then we can conclude. So let us try to understand the learnings. The learning is that there are penalties that can be imposed by IBBI, and there can be suspension of AFA, suspension of membership, and cancellation of membership also. The penalties can be 3 times the kind of loss caused to any other person or undue gains to anyone as an insolvency professional or any other related party, 3 times of that. And then there is a complete list of penalties that can be imposed by IPA. So all this can be considered, and all this can be seen, and the learning is that the valuer must be appointed even if there is no approval of the fee by the COC. Valuer must be appointed even if there is no clarity about the assets of the corporate debtor. The transparency in the auction is very, very important. There is no hurriedness in the conclusion of the auctions. The very, very high fee which can be given to the related parties, very high fee related to the given parties, even if it is approved by the Committee of Creditor, is not acceptable to IBBI. Even if that high fee is approved by the Committee of Creditors, because that is given to the related parties. So these are various learnings that we have seen today from the IBBI orders. And some of, so Ankit, I think then we can have questions. Delay in public announcement also, even if there is a settlement going on, delay in public announcement is also considered as a violation.
So no new questions, and I think we've taken care of a lot of questions in the interim questions that we took. So thank you, everyone. And I think this was, again, a lot of insight into what are the processes that IBBI wants, IPs to take care of. And thank you so much for being part of this session, everyone.
Thank you very much. Wishing everyone a happy Holi, and also finally saying that this is our way of learning. Thank you.
Thank you.